Chief Operations Officer. And next to the gentleman I introduced first is the Deputy Public Protector Advocate Kevin Malunga. And of course we have the Public Protector Advocate Busisiwe Mkhwebane, who now has the floor to address the House. Thank you.
Thank you. Thank you, Program Director, Mr. Sahale, DPP, and COO and COS, all the staff of the Public Protector. Thank you for coming to all the media houses. You joining us for the fifth and the last media briefing for the 2018-2019 financial year. Because in government the financial year ends in March the 31st. We meet at a time when the Public Protector South Africa family is mourning, having just lost one of our longest serving members of staff, Ms. Kathy van Rooyen, who passed on Monday. Many of you might have crossed paths with her because she was our receptionist, who was based at our front desk, and she has been with the organization for 18 years. And we take this opportunity to convey our condolences to the family, friends, and her colleagues. Her loss has made us to realize how important it is to have such a family member like her. Ladies and gentlemen, we have in the past 12 months made major inroads in pursuit of the objectives of our strategic blueprint, which is Vision 2023, the essence of which is to take the services of the institution to the grassroots. As such, I'm pleased to report that working within the little resources at our disposal, the team and I have reached out to so many remote communities, engaged these communities in their mother tongues, expanded our reach, and leveraged stakeholder engagement through mutually beneficial MOUs. We did not stop there. We put shoulder to the wheel to persuade organs of state to establish internal complaints mechanisms which will help reduce the workload of the institution, and also which will make sure that communities, when they've got complaints, they can hold the public servants to account. Of greater relevance to today's briefing, we continue to project this office as a safe haven for the poor and the marginalized, and we will continue doing that, and we will show in our reports which we'll be issuing today. It should be noted that in most of these complaints which were reported to my office more than 2 years after the course of action had risen, the exceptional circumstances include the nature of the complaint, the seriousness of the allegations, whether the outcome could rectify systemic problems in state administration, whether I would be able to successfully investigate the matter with due consideration to the availability of evidence or records relating to the incident, and whether there are any competent alternative remedies available to the complainant or the overall impact of the investigation. In addition, I take into account the provisions of Section 195 of the Constitution. Whether the circumstances are special or not depends on the merit of each case. All these find expression in the 8 pillars of Vision 2023. We will be presenting our annual performance report at the end of the financial year, where in the 6th Parliament, and we will be showing the performance of this institution in achieving its strategic objectives. I must also indicate that we will also be submitting our annual performance plan, which is incorporating this Vision 2023 pillars. We still believe in the vision that will help us to in our mammoth task of strengthening constitutional democracy. As most of you may be aware, I'm the president of the African Ombudsman and Mediators Association and the board of the African Ombudsman Research Center. which is based at the University of KwaZulu-Natal. And for the benefit of this umbrella body of 44 public protector-like institutions, we had a very productive training in Durban, and where we had one of the best professors in public law, which is Professor Mkhwebane, and we had a lot of African countries which were represented in the conference. We were in partnership with IOI, which is called International Ombudsman Institute, and where we also were provided training on mediation and conflict resolution. As you know, that Africa is facing that challenge, and that is contributing directly to Agenda 2063 or the AU Agenda 2063. Recently, we saw episode of unrest around the African continent, and we are working closely with our counterparts to make sure that we bring peace and stability in Africa. Let me move now, without any more delays, to the business of the day. I called the media to issue the following reports, and the investigations were conducted in line with the Section 182(5) of the Constitution, which makes it mandatory for me to make any report issued. That can be done unless there are exceptional circumstances where there is risk to national security. That report will be kept confidential. I confirm that no such risk exists, hence the following reports will be issued today. There is a closing report on an investigation into allegations of improper conduct and maladministration by the former CIPRO, which is Companies and Intellectual Property Registration Office, where it was relating to the implementation of the recommendations of the inspector's report. A closing report on an investigation into allegation of maladministration and improper conduct by the Minister of Police in the provision of SABC VIP protection services to Dr. Dlamini Zuma after the expiry of her term as chairperson of AU in October 2016. The report on an investigation into allegations of unfair and improper conduct by SITA, State Information Technology Agency, relating to the structuring of the pensionable portion of the remuneration package of Mr. G. Norton. The report on an investigation into allegations of maladministration by the Free State Department of Agriculture and Rural Development and the Department of Agriculture and Forestry relating to its handling of an outbreak of brucellosis on the farm of Mrs. Behrens. Report on an investigation into allegations of improper conduct and maladministration by the Eastern Cape Department of Health pertaining to the procurement of cleaning services for the Frontier Hospital. Report on an investigation into allegations of improper conduct and maladministration again Eastern Cape Rural Development and Agrarian Reform pertaining to the placement of learners in order to complete practical component of learnership program. The seventh report relates to an investigation into allegations of undue delay or failure by the Road Accident Fund to reimburse Mr. Ndlovu for expenses relating to burial of victims of motor vehicle accidents. Report number 8, a report on an investigation into allegations of improper conduct and legislative non-compliance by the KwaZulu-Natal Provincial Health in respect of KwaZulu-Natal government mortuaries, resulting in substandard service delivery at these mortuaries. Report on an investigation into a complaint lodged by members of the Greater Brakpan Taxi Association and the Johannesburg Benoni Brakpan Springs Secunda Wheatbank Taxi Association relating to an alleged failure by the Gauteng Department of Roads and Transport and Community Safety and the South African Police Service to enforce the law relating to operations of minibuses and minibuses. Report on an investigation, report number 10, into allegations of maladministration, abuse of power and improper conduct by the former executive officer of the Financial Services Board, Advocate Tsidi, as well as systemic corporate governance deficiencies at the FSB. Our main report or anchor report will be the briefing, which will be on systemic investigation into the illegal conversion of goods carrying Toyota Quantum panel vans into passenger carrying minibus taxis to transport members of the public. All this report falls within the backlog project, which has been one of the tasks delegated to the Deputy Public Protector. I'll now hand over to the Deputy Public Protector to take us through the reports.
1 up to which one? 1 up to 7. Okay, thank you. Thank you, ladies and gentlemen. Thank you, Public Protector. I don't know if we should shift these mics a bit. I don't know. Will that make a difference? Or I should shift to. Okay, we may have to shift temporarily, PP. Okay, thanks. Thank you very much, Public Protector, members of the media, and the Public Protector team. I will start off, maybe let me just start off by saying that this is the kind of stuff we do more on a day-to-day basis. Less of that sexy stuff that you guys are usually excited about. You have to wait for Bosasa for quite a while. CIPRO is the first report. Our office was approached by Messrs. L.J. Katikati, R.J. Roy, and W. Ngalo in December 2012 with a complaint against the Department of Trade and Industry. And it appeared from information obtained relating to the complaint that there were members of the Cape Town Harbour Fishermen Cooperative Limited, which was established in 1994. And in 1997, 25 cooperatives comprising 3,600 members formed the South African Commercial Fishermen's Corporation, SACFC, and the South African Commercial Fishermen's Holdings, SACFH. These entities were incorporated as companies in terms of the 1973 Companies Act on 31 January 1997. Mr. Katikati was chairperson of the SACFH, and according to the complainants, the former Minister of Trade and Industry, Mr. Mandi Simpahlwa, appointed inspectors in terms of the 1973 Companies Act on 2 February 2006 to investigate the affairs of SACFH and SACFC. The report on the investigation, inspector's report, was issued in 2008, that is more than 10 years ago. And the inspector's report recommended inter alia that anyone found guilty should be prosecuted. However, no prosecution was ever instituted. The essence of their complaint was that the DTI, and more in particular CIPRO, had failed to implement the recommendations of the inspector's report. And the complainants alleged that the said failure was improper, constitutes maladministration, and resulted in them being prejudiced. I therefore investigated whether the Minister of Trade and Industry, the DTI, and or CIPRO failed to ensure implementation of the inspector's report, and if so, whether such failure constitutes conduct that was improper or resulted in prejudice as contemplated in Section 1A21 of the Constitution, and or maladministration as contemplated in Section 641 of the Public Protector Act. Now, we've decided to close this matter for the following reasons. One, the period within which the liquidation proceedings in respect of SACFH and SACFC, as instructed by the former Minister of Trade and Industry in terms of Section 262A of the 1973 Companies Act, had expired years ago due to the advent of the 2008 Companies Act in 2008. Both the SACFC and SACFH had dissolved and do not exist as registered companies in terms of the Companies Act of 2008. No rational remedial action to address the failure on the part of CIPRO in 2009 to initiate the liquidation proceedings in the name of the companies can be taken due to the lapse of time. And the substitution of the 1973 Companies Act by the 2008 Act and CIPROP by CIPC. There's no substantive and verifiable evidence of prejudice suffered by the SACFC and SACFH. Of course, this is one of those cases which shows what happens when a case ages, and of course, remedial action sometimes becomes sort of redundant and impossible to implement. This is one classic case where this has happened. The next case is Dlamini Zuma. Now, we received a complaint from the DA Shadow Minister of Police, Mr. Zakhele Mbele, in April 2017, wherein he alleged maladministration and improper conduct on the part of the Minister of Police, Mr. Fikile Mbalula. In the main, Mr. Mbele alleged, one, that the media reported during April 2017 that Dr. Dlamini Zuma, despite being a private person who held no high office, was enjoying the protection of the South African Police Services, SABC, VIP protection services, due to the alleged security threats against her. Two, that spurious security threats were being used by the former Minister of Police as a justification to afford Dr. Dlamini Zuma SABC VIP protection services, which she would not otherwise have qualified for, and the former Minister of Police had failed to adequately and transparently make clear the basis of his decision to offer Dr. Dlamini Zuma VIP protection services. And that, thirdly, that policing resources and public funds were being used and possibly abused to protect an ordinary citizen when South African citizens face threats from criminals in their homes and on the streets on a daily basis. And on analysis of the complaint information and documents received during the preliminary inquiry, now, we decided to investigate whether the Minister of Police improperly provided SABC VIP protection services to Dr. Dlamini Zuma, and if so, whether such conduct constituted improper conduct and maladministration. Following an investigation, we arrived at the following observations and conclusions. Dr. Dlamini Zuma's protection by Presidential Protection Services, PPS, as African Union chairperson was in accordance with the practice prescribed by DIRCO, that is the Department of International Relations and Cooperation, and of according executive protection to dignitaries of her caliber. The protection by PPS was suitably continued after the expiry of the term of office of Dr. Dlamini Zuma due to threats identified by the State Security Agency, SSA, which also manifested during the assessment review conducted by Crime Intelligence. Dr. Dlamini Zuma was recognized in a document called Risk Management Support System Prescripts, RIMAS, which is classified as top secret, as a person entitled to be accorded SABC VIP protection immediately after the expiry of her term of office as African Union chairperson and during the handover from PPS to Protection and Security Services, PSS. And after conducting of the threat and risk review, when the level of risk had scaled down up to the time she became Minister for Planning, Monitoring and Evaluation, which is a position she currently holds. Having considered the complaint, the relevant provisions of RIMAS and other prescripts relied upon in providing Dr. Dlamini Zuma with the relevant PPS and PSS, now, we could not find any reason to conclude that Dr. Dlamini Zuma was improperly accorded VIP protection services by the Minister of Police. Now, the constitutional principle of separation of powers was reiterated by Mogoeng Chief Justice at paragraph 91 in the Economic Freedom Fighters versus Speaker of the National Assembly judgment, quoting from the court case in Certification of the Constitution of the Republic of South Africa, that is a 1996 judgment, where he says that the principle of separation of powers on the one hand recognizes the functional independence of the branches of government. On the other hand, the principles of checks and balances focuses on the desirability of ensuring that the constitutional order as a totality prevents the branches of government from usurping power from one another. Where the state institution has taken action based on its practice and prescripts within its sphere of administration, it would not be prudent for the public protector to interfere with the process concerned, unless where improper conduct or maladministration or through an act of omission or through an act of commission or omission manifests. Having regard to the evidence received, and remember we're an evidence-based institution, and for the reasons advanced herein above, I'm unable to pursue the matter any further, and I'm inclined to conclude that the allegations of improper provision of VIP protection services to Dr. Dlamini Zuma are not substantiated, and we have thus decided to close the investigation. The third matter is Norton. This relates to a complaint by one Mr. G. Norton, a now retired employee of the State Information Technology Agency, also known as SITA. He complained that when SITA amended its remuneration structure in 2004 and converted his salary to a total guaranteed remuneration package, TGP, he and other employees were prejudiced because SITA incorrectly applied the conversion and restructuring of the salary packages. He also complained that when SITA established its own retirement fund in 2004, members of the Government Employees Pension Fund, known as GEPF, were excluded from the opportunity to join the Alexander Forbes Retirement Fund. He further complained that when SITA reviewed its conditions of employment in 2008, which allowed staff to structure the unpensionable portion of their TGP to between 70 and 100%, the complainant and other employees were not allowed to increase the pensionable portion of their TGP in accordance with the relevant provisions of the SITA's conditions of service to their disadvantage. Now, we found that the allegation that SITA unfairly and improperly failed to comply with its statutory or contractual obligations to allow the complainant to transfer the actuarial value of his pension benefits in the GPF to SRF was unsubstantiated. Now, the allegation that SITA did not allow the complainant to increase the pensionable percentage of his TGP, that is the total guaranteed remuneration package, with effect from 1 September 2009, from 56.61 to the minimum of 70% provided for in the amended 2008 SITA conditions of service, is substantiated. The allegation that the complainant's pensionable emoluments in the GEPF were computed at a lower pensionable salary of 56.61 of his TGP instead of the 70% provided for in his conditions of service is substantiated. Now, as remedial action, I direct that the Chief Executive Officer of SITA engage the CEO of GPAA to facilitate the retrospective adjustment of the complainant's pensionables emoluments in the GEPF to 70% of his TGP with effect from 1 September 2009. Now, the CEO of SITA, in consultation with the Chief Executive Officer of GPAA, also known as GPA, must commission a full audit to determine the financial shortfall in employer and employee contributions on behalf of the complainant to the GEPF based on the retrospective adjustment of the complainant's pensionable emoluments in the GEPF to 70% of his TGP to 1 September 2009. My apologies for all these acronyms. That's what we deal with on a day-to-day basis. And of course, I think the rationale the public protector is putting across that in case the others were affected by this. And as a financial remedy to the prejudice caused to the complainant, the SITA must contribute to the GEPF 50% of the shortfall in pension contributions needed to adjust the complainant's pensionable emoluments retrospectively to 1 September 2009, provided that the complainant accepts liability for the balance of the shortfall in contributions which may be deducted from any additional gratuity amount accruing to the complainant. Now, we move from pensions to cattle. It's always, we cover a lot of different things. Barons. Now, we investigated allegations of maladministration by the Free State Department of Agriculture and Rural Development, DARD, and the Department of Agriculture and Fisheries, Department of Agriculture, Forestry and Fisheries, DAF, relating to its handling of an outbreak of brucellosis on the farm of Mrs. Ronelle Behrens. Now, brucellosis is a highly contagious disease caused by a bacterium called Brucella abortus. Clinically, the disease is characterized by abortions in the later stages of pregnancy. That is, I'm talking about cattle here. Retained placenta and decreased fertility. Humans are also susceptible by drinking unpasteurized, unboiled milk or eating undercooked meat of infected animals. The disease in humans is known as undulant fever. A product, RB51, is a vaccine registered in terms of the Fertilizers, Farm Feeds, Agricultural Remedies and Stock Remedies Act of 1947 as a stock remedy to be used for the prevention and or control of brucellosis. The vaccine was registered in 2002. The original registration holder was Sharing Plough, and the registration was later transferred to Intervet South Africa, now called MSD Animal Health, which company we interviewed. Ms. Behrens and her husband, Corbus, are dairy farmers on the farm Godemort in the district of Ventersburg in the Free State. The herd, known as Waterbrawn Jerseys, was inherited from the complainant's father, Mr. J.B. Haynes, in the 1990s. Since Mr. Haynes took over the herd in 1987 and officially registered it, the herd itself has won numerous prizes, which included being voted on numerous occasions one of the top 10 Jersey herds in South Africa. Some of the animals were also exhibited on various dairy shows, where numerous bronze, silver, and gold awards were won by them. 15 Mr. Suwe Boa awards were won by the complainant between 1994 and 2010. And all the milk produced on the farm was sold to Bandini cheese, where it was used to make mozzarella cheese. Now, in the main, I know you're not here to hear about cheese and things like that, but yeah. In the main, the complaint was that the complainant's animals were infected with brucellosis, despite the fact that they were vaccinated by the vaccine registered and prescribed by DAF, that is the Department of Agriculture and Fisheries. 2, that DAF unduly delayed and or failed to produce the complainant a report on its investigation into the suspended lack of efficiency of the RB51 vaccine. And 3, that the Free State Department of Agriculture failed to implement control measures in terms of the Animal Diseases Act 1984 on her farm after the outbreak was initially reported to it in 2010. 4, that brucellosis is a state-controlled disease in terms of the Animal Diseases Act, and that the state is therefore liable to compensate the complainant for her damages. Now, we investigated the allegation that the vaccine, RB51, was registered in South Africa without following due process, whether there was enough evidence before the Department of Agriculture and Fisheries to cancel the registration of the vaccine, and whether the department is liable to compensate the complainant for damages in terms of Section 19 of the Animal Diseases Act, as the Director, Animal Health, did not give an instruction for the slaughtering of animals as a control measure as envisioned by the Act. So a lot of her animals, a lot of her cattle died in the process. The allegation that the Free State Department of Agriculture and Rural Development, specifically Dr. Louis van Rooyen, failed to implement control measures stipulated by the Animal Diseases Act in 1994 and 2010 when the outbreak was reported is substantiated. The allegation that the Director, Animal Health, failed to intervene on the complainant's farm when the outbreak was brought to her attention in December 2010 is also substantiated. The allegation that the registrar failed to follow due process in terms of the Fertilizers, Farm Feeds, and Agricultural Remedies and Stock Remedies Act is substantiated. The allegation that the registrar had a duty to act on the reports upon the suspected lack of efficiency of the RB51 vaccine and improperly failed to do so is also substantiated. The allegation that the complainant suffered prejudice as a result of the maladministration of the Free State Department of Agricultural and Rural Development and the Director of Animal Health is substantiated. As I indicated earlier on, she lost quite a lot of her cattle due to the outbreak of, and of course these had to be culled and killed in the process. Now, in terms of the remedial action, I direct the Director General of the Department of Agriculture, Forestry and Fisheries, among other things, to issue a written apology to the complainant, apologizing for the manner in which the Free State Department of Agriculture and Rural Development and DAF handled the outbreak of brucellosis on her farm. This must happen within 21 business days of this report, that is from today. The DG must also, within 3 months of the date of this report and in consultation with the Minister and the Director of Animal Health, make an offer to the complainant which she deems reasonable in the circumstances as an ex gratia payment for the inconvenience, distress and frustration suffered by the complainant as a result of the maladministration. Upon acceptance of the offer by the complainant, the DG must pay the amount agreed upon by the parties to the complainant within 60 working days. The director responsible for animal health must, among other things, facilitate the process with the Department of Health to test the farm workers working on the complainant's farm for brucellosis infection. As I said, there's also the human version, and to ensure that the infected workers get the necessary treatment within 1 month from date of this report, and within 3 months of the date of this report, put systems in place in all provincial offices to ensure proper record keeping of notifiable outbreaks, and ensure that all instruction steps and advice are properly recorded for future reference. The director responsible for agricultural inputs control must, among other things, and in consultation with MSD, that is the company, liaise with Colorado Serum to satisfy himself of any further research that was conducted on RB51, and must, within 60 days, consider whether or not it may be necessary to amend the registration requirements of RB51 and or the necessity to test the product in South Africa. The director must take urgent steps to investigate the selling of an unregistered vaccine by Mr. Dan Hussein of Disease Control, South Africa, and consider whether it is necessary to institute criminal proceedings against him. The registrar is required to report back to the public protector on his investigation within 60 days from the date of this report. The next report is Jagavula. My office received a complaint in September 2015 from Ms. L.S. Jagavula, the owner of Kwezi Skills Training at KST. The complaint centered on allegations of improper conduct and maladministration by the Eastern Cape Department of Rural Development and Agrarian Reform regarding the placement of learners in order for them to complete the practical component of a learnership program and non-payment for services rendered in this regard. Now, I found that the allegation that the department unduly delayed the placement of learners in order to complete the workplace exposure part of a learnership program conducted in terms of SLA, of the SLA, that the service level agreement entered into with KST, is substantiated. And I also found that the allegation that the undue delay by the department prejudiced the complainant is substantiated. And I also found further that the undue delay by the department constitutes improper conduct as envisaged in Section 1821 of the Constitution, and maladministration as envisaged in Section 64A1 of the Public Protector Act of 1994. I remember this particular case, the complainant was actually very, very upset by this delay. And I directed that the head of department, HOD, to take urgent steps to pay KST the amount of 564,200 plus interest calculated in terms of the prescribed rate of interest Act as amended, I think there was an amendment, on the amount of 564 and 200 rand from the due date of payment within 30 business days of the date of this report. And I further directed the HOD to tender a written apology to the complainant for the undue delay in payment and the prejudice that she suffered within 15 business days from the date of the delivery of this report today. The next report is JADA. Ms. NC Jada, the owner of Vela Langa Cleaning Services CC, approached this office in January 2013 alleging improper conduct and maladministration on the part of the Eastern Cape Department of Health. This had to do with the procurement of cleaning services for the Frontier Hospital during the period 2007 to 2013. Now, we investigated whether the procurement by the Department of Cleaning Services during the period 2007 to 2013 for the Frontier Hospital was in accordance with the legislation and other prescripts regulating supply chain management, and if not, whether the non-compliance was improper and constitutes maladministration. Now, I found that the procurement by the Department of Cleaning Services for the Frontier Hospital during the period January 2009 to March 2013 was not in accordance with the legislation and other prescripts regulating supply chain management. And in addition, the allegation that the non-compliance by the department with the legislation and other prescripts relating supply chain management was improper and constitutes maladministration and is substantiated. And I always chat with the public protector about this, that this is a South Africa problem. It's not just the Eastern Cape Department of Public Procurement. This failure by the department constitutes improper conduct as envisaged in section 182(1) of the Constitution and maladministration as envisaged in section 4A(1) of the Public Protector Act. Now, to remedy this situation, I direct the HOD to take urgent steps to ensure that the procurement process for goods and services by the department is in compliance with the provisions of section 38(1) of the Public Finance Management Act, that is the PFMA, and sections 16A, 3, A5, and A6 of the Treasury Regulations and the Department's Supply Chain Management Policy to ensure, one, that the department has an appropriate procurement and provisioning system which is fair, equitable, transparent, and competitive and cost-effective. Two, that all employees of the department dealing with supply chain management are properly qualified and trained to perform their duties. And three, disciplinary action for misconduct against employees violating the provisions of the PFMA, Treasury Regulations, and the Department's Supply Chain Management Policy is taken without delay. Okay. Okay, also the changes here. Okay, the next one is Zandlovu. Mr. Zandlovu is the proprietor. Oh, now we're going to funerals. Right? We've left procurement and cattle. We're now at funerals. We are everywhere. Zandlovu is the proprietor of Ikaya Funeral Home. He lodged a complaint with our office in January 2017 alleging that the Road Accident Fund was unduly delaying or failing to reimburse him for costs incurred regarding the burial of victims of motor vehicle accidents. Now, in the main, the complainant alleged that he conducted funerals for victims of motor vehicle accidents, and that he entered into session agreements with the relatives of victims of motor vehicle accidents, in terms of which he, at his own cost, buried such victims and the bereaved families as beneficiaries with the right to make a claim against the Road Accident Fund for the cost of the funeral, ceded their rights to claim to him. He also alleged that the Road Accident Fund refused or failed to reimburse him for such costs as they indicated that they had put in place a tender for a panel of funeral parlors and service providers to provide such a service. Mr. Ndlovu further alleged that despite the existence of the said panel of funeral parlors and service providers, the Road Accident Fund had paid some of his claims and that he's entitled to be reimbursed for the outstanding 7 claims in respect of which he signed session agreements with bereaved families and had rendered a service. Now, we found that the allegations that the RAF unduly delayed or failed to reimburse the complainant for services rendered in respect of the 7 claims in accordance with signed session agreements is partially substantiated. The allegation that the complainant suffered prejudice as a result of the Road Accident Fund's failure to reimburse the complainant for services rendered is also is unsubstantiated. The complainant did suffer prejudice, but such prejudice was not as a result of improper conduct of the RAF. Prejudice was suffered due to the victim's family's failure to pay him the entire burial costs paid to them by the RAF. The complainant could proceed to institute civil claims against the families for the balance. And as a remedy, I direct that the Chief Executive Office of the Road Accident Funds should, within 60 working days from the date of this report, review the panel of service providers agreement to ensure inclusivity of service providers across the country in each local municipality to ensure that the SMMs are catered for. The CEO must also, within 90 working days from the date of this report, ensure that information sessions are conducted with the funeral parlors on the roles of the RAF's panel and the non-panel members. This will avoid recurrence of cases and complaints similar to this one of Mr. Ndlovu. Now, we are still dealing with the deceased. We'll move on to government mortuaries now. We've left the funeral parlors, we're going on to government mortuaries. Now, we conducted an investigation of allegations of improper conduct and legislative non-compliance by the KwaZulu-Natal Provincial Department of Health, that is the department, in respect of KwaZulu-Natal government mortuaries, resulting in substandard service delivery at these mortuaries. The complainants who lodged the complaint with my office on 8 May 2015 raised a diverse range of concerns relating to the practice of forensic pathology at the mortuaries. Upon receipt of this complaint, we engaged with the complainants in order to clarify and define the complaints to be investigated. Now, we identified and summarized the complaint as follows: that there were human bodies which were not properly identified, piling up on mortuary floors, trolleys and trays outside the mortuary fridges. 2, that there was a high volume of decomposed and or decomposing bodies in the mortuaries. 3, the mortuary managers did not possess the necessary and appropriate qualifications and experience to operate and manage the mortuaries. And there are labor-related matters that may have an impact on the provisions of services to the public. If I recall, there was a strike action at some point. 4, the mortuaries do not comply with the provision of applicable rules, laws, and regulations governing the performance of forensic pathology in South Africa. 5, the mortuaries did not have the basic, necessary, and relevant equipment as staff members to enable an effective public service delivery. And 6, there might be other issues that affect public service delivery in the mortuaries. Now, on analysis of the complaint, the following issues were identified to inform and focus the investigation. One, whether there is improper conduct by the mortuary on the part of the Department of Health in regard to management of human bodies at the KwaZulu-Natal government mortuaries. Two, whether the Department of Health improperly failed to employ suitably qualified and experienced personnel such as mortuary facility managers, forensic pathologists, and administrative staff at the KwaZulu-Natal government mortuaries. Three, whether the Department of Health improperly failed to remedy the forensic pathology officers' labor-related issues, thereby impacting on service delivery. Four, whether the Department of Health improperly failed to provide sufficient quantities of the basic, necessary, and relevant equipment at the KwaZulu-Natal government mortuaries to ensure effective and efficient service delivery. Five, whether there are other issues that affect public service delivery in KwaZulu-Natal mortuaries, focusing on the following. One, there is a lack of cooperation between South African police services and forensic pathology services, which results in the delay of proper burials, and also whether the Department of Health unduly delayed to issue outstanding post-mortem reports, and also whether the Department of Health improperly failed to manage equipment maintenance contracts, and lastly, whether any person suffered prejudice as a result of the conduct of the department. Having considered the evidence obtained during the investigation against the standard imposed by the relevant regulatory framework, I make the following findings: that the allegation whether there is improper conduct by the Department of Health and with regard to the management of human bodies at the KwaZulu-Natal government mortuaries is partially substantiated. The allegation that the department improperly failed to employ properly and experienced forensic pathologists is substantiated, and so is the allegation that the department failed to remedy labor-related issues pertaining to forensic pathology officers, I think resulting in their strike and so forth. The allegation that the department failed to provide KwaZulu-Natal mortuaries with sufficient quantities of the basic, necessary, and relevant equipment to ensure effective and efficient delivery, service delivery is substantiated based on the admission made by the department. They have already admitted to this. The allegation that there is a cooperation between, the allegation that there is a lack of cooperation between the South African Police Service and forensic pathology services with regard to proper burials is substantiated. Also substantiated is the allegation that there is a delay in the issuing of post-mortem reports. The allegation that the department failed to manage equipment maintenance contracts is substantiated. Substantiated too is the allegation that the KwaZulu-Natal community, specifically members of bereaved families, suffered prejudice as a result of the conduct of the department. The appropriate remedial action that I'm taking in pursuit of Section 182(1)(c) of the Constitution is the following. One, the head of the KwaZulu-Natal Provincial Department of Health must ensure that the department monitors the mortuaries quarterly to ensure that they comply with all relevant prescripts, that the department, the Directors General of the Departments of Public Service and Administration and Health must, within 30 working days of the date of the final report, and I believe that is today, provide our office with a full and detailed report on the process of regularization of the forensic pathology services, including the development of forensic pathologists' proper job descriptions and allocation of specific job functions. Three, the head of department of the KwaZulu-Natal Provincial Department of Health must, within 60 working days from the date of the final report, which is today, verify the number of vacant administrators positions at all KwaZulu-Natal provincial government mortuaries and provide my office with a full and detailed report on the measures being put in place to capacitate these mortuaries accordingly. And then 4, the head of department of the KwaZulu-Natal Provincial Department of Health must, within 60 working days from the date of the final report, develop the standard operating procedure for the use and safekeeping of the mortuary equipment, including the security measures to prevent the theft of equipment. I see people steal even from mortuaries. 5, the National Commissioner of Police and the DG of the National Department of Health, including the head of department of KwaZulu-Natal Provincial Department of Health, of Cooperative Governance and Traditional Affairs, I beg your pardon, must, within 60 working days from the date of the final report, ensure that in line with the constitutional spirit of cooperative government as provided for in Chapter 3 of the Constitution, establish and sign a memorandum of understanding to regulate the cooperation in the proper management of all government mortuaries, including provision of land to conduct paupers' burials on time and the possibility of cremating the unknown human bodies. Let me just liaise with the Public Protector shortly as to where I should stop in regard to up to which report. Okay. Right. Okay. Thank you. Oops. Where's this one? Okay, Brakpan. Right, we are moving, we're done with the deceased. We can come back to life now. We're now moving back to taxi associations now. That is the Brakpan Taxi Association, which is the last report I will render before handing over to the Public Protector. Now, we received a complaint from the members of the Greater Brakpan Taxi Association, the GBTA, and the Johannesburg Benoni Brakpan Springs Secunda Witbank Taxi Association, JBBSSWTA. Okay, in February 2012, these are all old matters relating to an alleged failure by the Gauteng Department of Roads and Transport and the Gauteng Department of Community Safety and the South African Police Service, SABC, to enforce the law relating to the operations of minibuses and midi-buses, that is taxis. Now, the complainants are members of the associations that I've mentioned earlier on, operating on a route between Brakpan and the Johannesburg Central Business District. Now, in the main, the complaint was that law enforcement agencies in the Gauteng provincial government, that is the GDOCS and GDRT and the SABC, were failing to enforce the law and a court order which prohibited illegal taxi operators from operating on the illegal routes allocated to JBSSWTA and the GBTA. The complainants indicated that they were adversely affected by the deliberate deviations and the non-compliance of the relevant organs of state with the resolutions adopted during the interstate agencies meetings. It was their contention that lack of proper law enforcement in the taxi industry had caused adverse effects which included violent assassination of at least six of their members. The GDRT and the GDOCS and South African Police Services did not dispute that there were issues plaguing taxi operations surrounding the routes allotted to the two associations. The departments involved, however, disputed that challenges experienced by the complainants were as a result of their inaction or failure to enforce the law. Upon investigating, we found that the allegation that the GDRT, the GDOCS, and the SABC failed to enforce the law in respect of the operators of the minibuses and midibuses operating without licenses and permits is partially substantiated. Now, among other things, the 2007 court order, which the complainants sought the Gauteng law enforcement agencies to enforce, was subsequently rescinded on 16 October 2012, and therefore unenforceable. The Gauteng law enforcement agencies also failed to prevent members of the GBTA splinter group from operating taxis without operating licenses, which was in contravention of the Section 50 of the Transport Act, and also duplicating the route between Brakpan and the Johannesburg Central Business District in contravention of the Section 63 of the Transport Act. Now, the GDC